Hi. My name is Elizabeth, and I have a confession to make. I'm a recovering lawyer. I'm sure that you're all trembling with excitement at the idea that someone's going to speak to you about a piece of legislation for 20 minutes. So I'm going to try and keep it as light as possible. I'm kind of glad that Wayne ended off on a kind of a information governance or data-driven discussion towards the end of his presentation, although I suppose all of it really these days, everything we do is data-driven. So maybe just by way of background, when I say I'm a recovering lawyer, about 7 years ago I escaped from one of the big corporate firms in Sandton. They wouldn't let me wear jeans to work. The dress code has become somewhat of a metaphor in my life because, in my company, we really strive to package law in a different way. And then it should come as no surprise that one of our areas of speciality is innovation around data management. Now, why is that a hot enough topic that I got asked to speak to you guys today? Well, there's a piece of legislation coming. It's called the Protection of Personal Information Act. All right, so first of all, what is the Protection of Personal Information Act? Now, the last 5 years, I would say, probably on at least a monthly basis, you would see extensive media coverage on these large data breaches, right? So the one that immediately comes to mind is Equifax last year, where 123 million records ended up online of Americans. So I don't really care about that so much. But that company probably won't see the end of the year, right? And so we look at these breaches and we think, okay, there's a legal risk because, there's a piece of legislation, but actually this is very much about reputation. And if I extend that to the crowd in front of me, when we talk about POPI, or the Protection of Personal Information Act, what you need to understand is that there will be rules coming into force in about 20 months' time that will change the way, fairly fundamentally, how we collect information. So in other words, your online forms, how and what we do with that information. But more importantly, and I think for you, is it will fundamentally affect the way in which we do things like profiling. So in other words, that thing that we do in order to package products and services in a way that is particular to a customer. Personalization. I have another confession to make. Personally, I love it when companies do that. I love it that Amazon has a fairly educated guess as to what I'm going to read next. I like it when I receive emails from retailers who have picked up, I don't know how, that I am the mother of 2 small children. So I like the fact that I know when nappies are on special. I don't like it when I get a phone call, in particular from insurance companies. That is a little bit of a pet hate, particularly if it is an insurance company that I've never heard of before. Okay. And what we are talking about today, when we talk about the regulation of direct marketing, because that's actually the theme for the day. I could speak probably for a whole day on profiling, etc., but the theme for today is that direct contact that you make with customers. It doesn't really matter which channel. POPI will regulate all digital channels. Unfortunately, it won't regulate telemarketing, which I think is the worst form of spam. But when we talk about digital direct marketing, what is it that's going to change going forward? And it's an incredibly important question because most companies, or many companies who do digital marketing, it is a very real place in their strategy to drive sales, for instance. So, for instance, if POPI compliance means that they're going to lose 90% of their list, that is a fairly serious thing. I don't take legislation seriously. I think legislation is a really crap way or crap reason to do anything. But the idea that, I have clients who might lose the ability to contact 90% of their database, that does scare me a little. It gives me pause. So, point is, don't think legislation is important in general, but this little bit of legislation really has the ability to change things quite fundamentally. Right, so why do we care? Well, we care obviously about protecting our clients, strategies and operations, so we want them to be able to do business tomorrow once the act comes into force, but also we want to protect their reputations. So the reason why companies that suffer massive breaches go under is because people lose faith in you. If they don't trust you, they're not going to give you the information. If a large part of your target audience is millennials, they do, and we know this because there's been research, they do use, can I trust this company as a way to decide, am I going to give you my information? So it is an incredibly important question to answer from a strategic point of view. Right, so what has changed? Right, so again, I just want to confirm, I'm talking about unsolicited digital contact, right? So email and other forms of digital communication, so in-app communication, etc., right? At the moment, the South African law is you can contact whoever the hell you want until they tell you to stop, right? And you have to be respectful when they tell you to stop. So, for instance, you can't follow what we like to refer to in my office as the Groupon approach, right? I don't know if any of you have ever fallen into this kind of trap. I obviously sign up for a lot of things because I'm interested to see how people do it. Sign up for Groupon's newsletter, right? Now I start getting newsletters, but I don't get only one newsletter, I get about 16 a day. Every time I get them, I now unsubscribe, because that's why I subscribed. I wanted to see their unsubscribe process, yet the newsletters keep on coming. So eventually I phone them, and I say, look guys, what's going on here? I unsubscribe time after time, and I'm still getting your newsletters. And the answer was, well, no, actually, when you unsubscribe to this newsletter, you are unsubscribing to newsletters about B&Bs for less than 300 Rand in Joburg. It's genius, really. You've got to respect the genius behind it. But as a customer, that is incredibly frustrating. Right. So we currently have this situation where we can contact whoever we want until they tell us to stop. Right. This is going to change fundamentally. What this piece of legislation says is that before you can do direct marketing, before you contact a person, you are going to have to ask for their consent. And this consent needs to be an opt-in. Right? So what's the difference between opt-in and opt-out? With an opt-out, the default is, I can send you my stuff unless you tell me no. An opt-in is, I can't send you my stuff until you tell me yes. That is a fundamental change for one reason only, and that is, as we know, there's such a thing as customer or consumer inertia, right? So if you ask them to do something, half of them won't do it, even though they do want the marketing. That explains why if you send out an email campaign asking people for their consent, probably 10% of them are going to answer, yet when you do a survey on the rest, you'll find that half of that remaining 90% want the marketing, they just couldn't be bothered to reply or to tick a box. Very frustrating, but true nonetheless. Right, so that is a fairly fundamental change. Then, the question that we often get asked, though, is, and I think there are some of you in the room who've asked me this before, is, okay, I have an existing list, like my customer, or my client, or my company, we've been doing direct marketing for 20 years. We used to do it via carrier pigeon, and now we email them. Okay, so you have a list that you built up over 20 years, and the question is, in 20 months, when POPI comes into effect, can you the next day email these people, or do you have to ask them for their consent first? And again, that is a fundamental question. Because if you have to ask for their consent first, you're looking at about, between 80 and 90% reduction in your list. You don't want to have to ask them for consent again. And actually, for once, we have a piece of legislation that was drafted according to international best practice, although I'm going to show you the draft regulations just now that most certainly weren't. But the act itself says, okay, well, we understand that is not something that we necessarily want to do to you, because let's say you have 20,000 customers who you've been contacting on and off for 10 years. By now, they would have unsubscribed if they don't want the communication. So there's kind of like what we call a soft opt-in, right? They haven't told me no, so they must mean yes. Only works in certain situations, as many men have found out this year. It's the Kevin Spacey thing, man. I walked into that one. I wasn't planning it, I promise. Right, so how do you make sure that you don't have to do this in 20 months' time? Like write an email, say, sorry, can I still contact you, to sell you sneakers? No one here from Superbalist. Love your stuff. Right. I have to be very careful in these sessions because I always kind of scared that I'm going to, say something crappy about a company who's actually represented. So I try and Groupon I don't think exists anymore, so that was a safe option. Right, so what you need to do is you need to make sure of two things, and that will mean that you don't have to contact people again, in future, the guys who you want to, who you're already marketing to. Firstly, you have to ask yourself, well, when they gave me their information, did we tell them that we are collecting it for direct marketing? That's not to the extent that you can answer this question. Half the time we don't know where the hell we got the data in the first place, right? It's just a data dump that we did out of some kind of system and we cleaned it up a little bit and off we went, okay? Often, not always, right? So do we know whether they had an inkling that they were giving their information to me in order for me to market to them? The second thing that you need to make sure of is, have we always given them the opportunity to unsubscribe from this marketing? Right, so if you are not doing that right now, although most companies I think do, make sure that you start doing that. If you don't know the source of your data, and this is now where I think we differ a little bit from traditional lawyers, is the answer, they won't give you a clear answer there about what do you do now. They'll say, well, the Act requires you to contact your customers. No, well, yes, but that's not a very useful piece of advice because it's going to kill your ability to contact those people. So generally speaking, what we advocate for is sort of a risk-based approach. So we say, well, these people haven't opted out. I have a strong opt-out, they unsubscribed, so I take it they want to hear from me. We'll communicate to them about POPI, or we'll communicate to them about privacy, but we'll do it in an opt-out kind of way. So we'll say, well, this is happening, and we respect your privacy and all those lovely things. I mean, we have a whole bunch of writers who specialize in fooling people into trusting me all the time. They work very hard. So you do it in a way that reassures them, and then you say, look, if you are uncomfortable and you don't want to receive marketing from us anymore, let us know. But then I'm now taking advantage of that customer inertia because I've changed it into a very respectful opt-out. I think that's enough. The worst thing that can happen is that the regulator disagrees with me, but frankly, they're new, they're only going to pick up steam in another, that usually takes regulators about 4 years. Okay, so honestly, that's my bit of free advice for the day. Take it or leave it. Well, I mean, whatever. Right, so actually, I think one of the biggest impacts of this legislation, which hopefully will make, anybody from ABSA here? Okay, well, if I was from ABSA, I wouldn't put up my hand right now. Let's hear what she's got to say. If ABSA contacts me one more time about funeral cover, there will be a funeral. Can I get an amen? There you go. See, I thought you were a difficult crowd. You're not. Right, say dankie vir die tannie. So, the biggest impact of this legislation is going to be, and if you have clients, or if your company is in the practice of doing this, then you need to sit up and listen, right? If you are buying data, now most companies do this to a degree, but if you are buying data in order to send them direct marketing, so you are buying or selling leads, this act will make that very difficult. Even if you look internationally, generally what is required if you want to do that is not one opt-in, it's two. First, you have to ask for their consent to sell their information, which sure, everybody's happy when people sell our information. Secondly, you're going to have to ask for their consent for this third party to whom you are selling it to contact them for direct marketing. That's a double opt-in. So if I were in the business of buying and selling leads right now, I'd be fairly nervous. Because that is a tough ask. Obviously, we also buy data for other reasons. Sometimes we buy data in order to enrich the data that we already have. There are various ways of still doing that in future, but it is going to have to happen in a more controlled fashion. You're going to have to be very circumspect about who you buy the data from. Most of the, I find that about 9 out of 10 times the company selling the data is in the Ukraine for some reason. But yeah, well, let's leave that aside for the moment. Possibly take out a hit on me or something. But what those companies do is they prospect the internet, right? So prospecting is traditionally kind of like a mining term, but they literally mine the internet. So they'll find my work address, email address, and they'll sell it to whoever wants to purchase their list. That's how the other day I'm doing a POPI compliance project with a university. As it happens, a university that I got a degree from. Yes, I have a degree, a real one. And all of a sudden, I'm getting emails asking me for donations, which qualifies as direct marketing at my work address. Now, I know they've never had my work address, the alumni office. They've always had my Gmail address, because that's where I send email that I want to ignore, right? Gmail, where email goes to die. So obviously, I'm not doing this POPI project, which is, I mean, the irony abounds, right? So I phoned the alumni office, and I'm like, well, guys, I mean, I've never given you that email address. Sure, other people have that email address, but I don't want you to have it. Like, oh, no, we bought it from a company in the Ukraine. But here's the point, right? Privacy is as much about not having your stuff exposed to the world as it is about having control over your information. There is a very solid reason why I give my Gmail address to marketers. It's so that it doesn't clutter up my work inbox. So once a day, I will log into Gmail, and I'll read all of 20 emails from Superbalist and Woolies and all of those guys, but I do that at my leisure when I have time. I don't want it in my NovCon address, right? So don't you dare, any of you. So that activity of enriching data, buying data, etc., is going to become more difficult. Not impossible, and certainly, actually, for companies who are behaving ethically in the first place, some of this won't be news, because customers hate it. They really don't like unsolicited contact. So in general, we find that companies who care about what their customers care about don't tend to engage in this kind of activity. Right. So we've spoken about the difference between an opt-in and an opt-out, but there are various rules that will apply in future to the consent, and then we get to the meat of the matter, which is this fucking draft regulations. There's no other word for it, you'll see. Draft regulations that the information regulator issued, which I'm going to show you just now. You will weep. I am going to set myself on fire if that thing goes through. It's a known legal tactic. Right, so the consent must be voluntary. So that means it can't be a fit in or fuck off consent, right? So I hate those consents where they say, well, you hereby consent to us using your personal information. I go, hold on, I pick up the phone because I'm a pest that way. I'm like, okay, I don't consent, but I do want the sneakers. So they're like, well, you can't have the sneakers. I'm like, well, then that's not a consent, right? Actually, you've just told me that you're going to use my personal information. We've tested this. Yes, a lawyer that does usability testing, the mind boggles. We've tested this on actual people, because we're not actual people. We tested this on actual people, and they hate that. And with a surprising sort of, there's a sort of a visceral, emotional quality to this hatred. When you ask them for their consent, but they know that they're not stupid, they know it's not a real consent. So actually, you're just pissing them off. And POPI doesn't require that you get consent for those things anyway, although 90% of lawyers seem to think so, which is because they only read the first part of a certain clause. They don't go to A. Okay, great, awesome, we're just going to ask consent for everything. And you pay them by the hour. Like, one would think that they can make more money if they read. Right. You don't have to ask for consent for everything. It's just consent for direct marketing. Okay, but that consent can't be structured in a way where if I say no, I can't get access to the service, because that's called extortion, right? Okay, so it has to be voluntary. It must be specific and informed. It can't be like, oh, you hereby consent to me doing what the fuck ever with your data. It can't be that, right? It has to be very specific. Best practice with direct marketing consent is that you also give the person an inkling of how regularly you are going to contact them through which channel. Okay, so that is considered best practice. People love that. Because then I can make an educated decision about whether I'm going to use Gmail or my work address. And it must be an expression of will. That means it can't be passive. An opt-in means they actually have to tick something. It can't be pre-ticked. A pre-ticked opt-in is an opt-out. Right? So remember that default rule, right? So if default is I'm going to send you stuff unless you do something, they have to do something. They have to actually opt in. Okay. this is what happens when lawyers do form design. Isn't it beautiful? So the regulator is allowed in terms of this legislation. So POPI's been signed by our previous president. Another amen, please. That's not going to change, but the regulations can change. So the regulator has issued draft regulations, and one of the things they had to regulate is, okay, well, what does this consent look like? Lo and behold. Right, so Form 4. I now just have a hatred of the number 4 after this, but anyway, application for the consent of a data subject for the processing of fucking hell. Right? Okay, so and now I have to, this is the other thing, this thing is not technology neutral, it requires a pen and paper, baby. I have to now fill out this form. Also, fax number. I don't know, I mean, at least ABSA doesn't spam me via fax. So there's something to be grateful for. It could have been worse. Right? They asked for my contact numbers. Okay. I'm okay with that. Email address, sure. And then Mr., Miss, Doctor, Advocate, Prof. They all have doctorates. So there's this weird focus on academics. Right, and then it launches into a restatement of Section 69 of POPI. Now, again, I ask with tears in my eyes. I mean, I don't actually know even what to ask. Definition of processing. This is about direct marketing. All right. Then a list of personal information. Fantastic. Although irrelevant. And then also a signature of the person authorized by the responsible party. So are you telling me that Ian Moore from Woolworths will have to sign every time someone signs up for W Rewards? Right? This is a standard thing. Standard terms don't get signed. That's why they're there. The self-loathing gets particularly hectic roundabout when I see stuff like this. Okay, so one would think now we're done, right? Because it's already 2 pages. How much worse can it get? Well, right, now you have to date it. Then I must write out my name. Fantastic. Consent to goods and services to be marketed by means of unsolicited electronic communication. Okay, great. Well, now I have to specify the goods and services. Now that one baffled me. Am I now having to consent each time Willie sends me, I'm not picking on Woolworths, this is a fan of W Rewards. Is this every time they run several hundreds of campaigns at the same time. Do I have to consent for each and every one? I mean, that's going to basically kill my ability to do work. I'm just going to sit and sign direct marketing forms all day. Then I say, okay, again, fax, email, SMS, others, specify. Well, Norman, my carrier pigeon. I'm always surprised when people laugh at the second carrier pigeon joke in 20 minutes, but all right. I tick, give my consent, tick, do not give my consent. I love it when I have to tick twice for one question, and then I sign it. Signed at this, the day of 20 what? I don't know. I can't talk about this really. It fills me with a feeling that I can hardly put into words, except I did put it into words. We wrote them a submission. So for my sins, or it might be because I wear jeans and I'm just less scary than normal lawyers, I'm the chairperson of the Regulatory Affairs Council for the IAB. Right, and of course this made us very angry. It's basically what we were put on this planet for, is to respond to this kind of thing that threatens, I really do think it threatens sections of the marketing industry quite severely. So we made some submissions. I'm not going to take you through them. One slide, bigger is not better. Actually, that line just read 5 pages, really? Really? Plain language, please. Right? I mean, they've reproduced the piece of legislation. There's not someone here from the information regulator, is there? It's maybe a bit late to ask. Love your work. it's not technology neutral, right? The minute you ask someone for their signature, it's not technology neutral. Let's assume, and this is a big assumption for the moment, that they've heard of electronic signatures. Not everybody has an electronic signature. The minute a piece of legislation requires a signature in a contract, it has to be an advanced electronic signature. Right? The last time I had to use one was when I was signing a surety for my house. This is just direct marketing, people. Right? So it's not technology neutral. The answer to that is, well, you know, it just needs to be substantially similar. But I'm like, okay, well, does that mean I can leave stuff out? Because then I'll leave out the entire thing. Anyway, so a signature, really? Why? I don't understand. How many consents do you need? Is it per product, per campaign, per retailer, per channel? Where's social media? I suppose that's others, specify. Right? But where's social media? And whatever new way we're going to find to communicate with people tomorrow, because, I mean, it changes every day. And then, worst for me, I mean, yes, the legislation, international best practice, I don't think they went and looked at a single jurisdiction. And what they would have, a foreign jurisdiction, what they would have found is, you don't tell the marketing industry, here is your form, you write guidelines. The context is too specific when you guys work. Every time you design a campaign, there's a specific context. I won't want to design a form that suits every single one of those contexts. In our submissions, which admittedly that was a little bit tricky, we said, how about this one? And we wrote some guidelines for them based on what's done in Europe, etc. I mean, that's the other thing. As we all know, increasingly marketing is a global game, right? I mean, as you guys sit here, you're not just marketing to people in South Africa. Some of you are designing campaigns for companies that aren't even in South Africa. So if we have legislation that's this batshit crazy, and the rest of the world, except for America, isn't batshit crazy, then that puts us at a disadvantage, right? So that was one of the biggest points that we tried to get across, was this is just bad economics, right? Please don't. So what now? We're still waiting for the new draft of the regulations. They won't give them to me. I wonder why. No, they're keeping them quite close to their chests. I suspect because they don't want to go into another round of public comment, because they got about 5,000. No surprises there. So let's say the worst case scenario in my mind is that they just republish the same thing. Right? Now we sit with this thing. So what is our safety net? Well, we could always take them to court. It'll be fun, but, you know, cost a bit of money. And you don't want to piss off the regulator. Well, I make a sport out of it, but, you know, in general. So there is another option. And it's something that the IAB is very seriously exploring at the moment with various stakeholders, is can we, and the Act provides for a draft, a code of conduct for digital marketers. And will that mean that if you follow the code of conduct, you don't have to use Form 4, right? And it's entirely possible. There are many industries on behalf of whom we are drafting those kinds of codes of conduct, because what we are saying is there are specific concerns that need to be taken into account here, so please, please, please listen to the experts. Although it's funny, I'm not, you know, I'm deeply uncomfortable with the word expert. So that is why you might, in the coming months, see, you know, requests to give your input on a draft code. Or we might say, come, we're having a working group. Right? Afterwards, I'll bribe you with wine or something, which you'll need after a working group. But please take an active role in this process. Obviously, we are trying very hard to lobby them to change the regulations in the first place, but my experience in the past has been that at this point in the life of a regulator, they're so busy putting carpets in, buying computers and renting premises and hiring secretaries that they don't really have time to listen to like other people. So we're obviously going to try our best to get that done, but otherwise, you know, we're gonna not leave it there and come up with a code that makes sense. In the meantime, this is maybe a little bit blasphemous. POPI is coming. Look busy. As I said in my first slide, you have probably about 20 months. that's because they're going to probably publish an effective date in the second quarter of this year, and then there's a 12-month sort of moratorium. They're not allowed to go after anybody. Okay. But make sure that you try and find out where your lists came from, so that you can start thinking about what your strategy is going to be to make that list compliant. Because even if your own company doesn't require it, if you are working on behalf of a client, so if you are working for an agency, your customer or your client is going to require it. So they're not going to want to get into trouble. Right, so let's think about where your lists came from. Try and find that out. If you are not recording the origin of information at the moment, you need to change that in your database. You need to know where stuff came from. Where did I get it? What was the context? What was that person told when they gave the information? If there was a consent, what did that consent look like? Those are all things that in future you are going to be required to be able to show to a regulator. Then check whether you are asking for consent currently. It's always a good idea, even if it is an opt-out. So even if it is a pre-ticked box, it's always a good idea to make people feel like they are in control of their data. We also know that your direct marketing is only as good as your open rate when we talk about email. And people who didn't ask for emails literally teach themselves within 5 minutes to ignore it if they're too lazy to unsubscribe. So in any event, an audience who, at least if there was like a head fake towards consent, tends to be a more motivated reader of your content, right? And then the other big thing, though, is often I get asked for advice by really nervous executives because, we've worked so hard to build up a 1 million-person database for our newsletter. And now POPI is coming, and they can't deal with it. There's a difference between unsolicited direct marketing and people who signed up for a newsletter. Because I am a foodie, I always like to use the example of Eat Out, right? So Eat Out as a brand, they've got newsletters. And I went onto their website, and I gave them my email address under the question, do you want to receive our newsletter? That is obviously not unsolicited. I solicited it. If they then went on and sent me all kinds of other stuff, sure, that's unsolicited because I only signed up for the newsletter. I didn't sign up for all of the other promotional stuff. That they need to ask me first. But so if you can structure whatever content marketing you are doing, however you are delivering your native content, whatever the case may be, if you can structure it that it is kind of something the person signed up for, like a newsletter, or part of the service that we are rendering. In other words, part of what we do for you as our customer is we'll send you updates about things, right? So you position it as an information service. That's the best thing, because then you get away from the direct marketing provisions altogether. Because, whatever they come up with now, it ain't going to be pretty, right? So that is kind of first prize. All right, I think I am pretty much done. This is about generally as much of me that people can take, or lawyers maybe. I'm going to be around today, so if there are any questions, just come and ask me. But thanks, you've been real.